Bismillahir Rahmanir Rahim. Alhamdulillah. Wassalatu wassalamu ala Rasulillah. Sayyidina wa Nabiyyina Muhammadin ibn Abdullah wa ala alihi wa sahbihi wa man wala. Let me begin by thanking the organizers for inviting me to participate in this extremely interesting and enlightening webinar. I've had the opportunity to listen to great scholars, and I'd like to thank them for this opportunity. Mufti Menk, Sheikh Fantami, Ustaz Abubakar Siddiq, Imam Ali Agan, Reverend Job, Pastor Washika Nur Lemu, Reverend Monokwa, and other panelists. I would like to thank you for giving this issue the attention it deserved and covering it from the various perspectives of the two religions. I've been asked to speak about the contemporary challenges facing Sharia legislation on rape and domestic violence. And just to give a little bit of context to this topic, we know, for example, that we have at least 12 states in northern Nigeria that, going back to 1999, 2000, 2001, declared that they were adopting Sharia law. One of the most interesting things about these states, when you look at them, is that between 2000 and today, which is 20 years, with the exception of the criminal law, none of these states has passed any Sharia law. Family law has not been codified. Law of contract has not been codified. And you end up with the impression that Sharia law is limited to amputating the hand of a thief, stoning an adulterer, whipping someone who's drunk alcohol, and that's it. All the other things around the family, around relations, around marital relations, around the age of marriage have not been codified. Now, this was an issue for me. And I remember in 2014, when I became ABA, one of the first things I did was to set up a committee of religious scholars to try to codify a Muslim law of personal status. And it took us 3 years. Now, the reason this is important is for you to actually legislate in Nigeria on Sharia. As Sheikh Nur said, you have to involve the scholars. Sometimes you have to debate with them. Sometimes you have to force them to research. You have to force them to think. Sometimes you have to force them to look at what other Muslim countries have done, Malaysia, Tunisia, Morocco, Egypt, and try to explain to them that we are not the only Muslims in this world. How come the scholars in those countries have accepted these changes? How come we're not accepting them? Now, part of what I'm going to talk about on rape is to say, going back to that experience, how you use the classical Islamic law as a foundation, because you can't get rid of that, and how on that foundation, and based on that foundation, we can legislate for the contemporary world. What are the issues? And also, from my experience in the production of that Muslim family law, some of the things that perhaps we have been blind to, because sometimes the issue is not so much the people, it's not so much the scholars, it is actually something beyond that. So I'm supposed to speak about the legislation for rape, and some of that has been discussed by Sheikh Nur. I'll try not to repeat what has been said, other than to endorse and to say that I support certainly everything that's been said by all the scholars that have spoken before me. Now rape in classical Islamic jurisprudence has been looked at from two different perspectives. The vast majority of scholars have treated rape as an act of zina, which is adultery or fornication, and also liwat, which is sodomy accompanied by violence. A minority have treated it as a case of haraba, which is brigandage, similar to armed robbery, and I will come to that and the arguments that they have. Now, depending on where you classify rape, there are serious consequences and implications for things like the law of evidence and also the punishment. And the reason is that the Islamic law on adultery and fornication and the law of evidence is actually geared towards protecting the integrity of people and protecting them from being falsely accused and slandered. And that is the reason. Because, and in fact, the context in Surah An-Nur was a slander on Aisha, the wife of the Prophet sallallahu alaihi wasallam. So the law of evidence, when it comes to fornication and adultery, is designed to make sure that only when you have absolute proof, incontrovertible proof, do you accuse anyone of committing adultery or fornication. And that's why you need 4 eyewitnesses, or a voluntary confession which can be retracted. In fact, some scholars say the confession must be given 4 times. And it's not just a confession to say, oh, I committed adultery. You must confirm that you actually penetrated. You must confirm that you knew it was illegal. You must confirm that you knew it was zina and all that, and that you were in your senses before you are convicted. Now, the problem with taking rape and treating it as zina with violence is that inadvertently, the rapist enjoys the protection that is given to an average human being whose reputation is being protected. On the other hand, if you took rape as hiraba, the law of evidence is different, principally because that law is aimed at protecting the society from the aggression of criminals. And therefore, you do not protect the rapist, you protect the victim. Whereas if you took it as a case of zina, you would be protecting the rapist without meaning to. Now, the vast majority of Muslim scholars in the past, the Hanafi scholars and the Hanbali scholars and some Shafi'i scholars, treated rape as a case of zina with violence. In Maliki law, certainly, and I think Sheikh Nur referred to Ibn Arabi, there's also Imam al-Qurtubi. And if you look at the commentaries on the text, if you look at Ulaysh, Minahul Jalid, if you look at Dasuki's Hashia and Shaykh al-Kabir, in Maliki law, there is a very strong position that rape is a case of hiraba. It is linked because at the end of the day, the underlying commonality is that somebody uses force or fear or intimidation to take away from people that which does not belong to him. It doesn't matter whether it is life or property or somebody's sexuality or somebody's dignity. So hiraba as a crime is one that also involves fasad, that's causing corruption in the land. And therefore, the Maliki position fundamentally is that rape is seen as a case of hiraba, as a case of transgression or brigandage, rather than as a case of zina. Now, what are the implications of that? In hiraba, you don't need four eyewitnesses. You need 2 witnesses. In hiraba, one of the witnesses can be the victim. Therefore, if a woman is raped or a man is raped, their testimony is taken as that of a witness. If you do not have a witness to the act, you are allowed to have circumstantial evidence. This circumstantial evidence could be, for example, the girl screamed and somebody saw the person running away. It could be some semen that he left that goes through some tests in the lab and you establish that this semen belonged to him. It could be even that the person who is accused of raping has a history of bad behavior. All of these can be taken as corroboration to the testimony of the victim. Now, so the implications are very clear that if you take rape and link it to hiraba, you are then able to lower the standards of proof and therefore get more and more of these criminals into the net. Whereas if you treat it as zina, you provide opportunity for 99, in fact, 100% of rapists to get away, because unless they confess, you're going to need 4 eyewitnesses. I remember that for zina, you don't just need 4 people to say, I saw him on top of her, I saw naked people. These 4 people have to actually say they were eyewitnesses to the penetration. It's totally impossible. So So I think the first thing is, if we're dealing with contemporary, unfortunately, we're in a Maliki jurisprudence. So if you are going to write a law under the Sharia, it is important, I think, to first of all accept the Maliki position that rape is an act of hiraba. And in that case, it doesn't really matter whether you have 4 eyewitnesses, no matter whether he confesses. The testimony of the victim, along with circumstantial evidence, would be sufficient to convict the rapist. If he confesses, that is fine. Even if he does not, these things are taken into consideration. That is the first thing. The second thing with Islamic jurisprudence is that in every discussion of rape, ghasab or iktisab, the victim is a victim. The rapist is a criminal. The victim is innocent. There has not been a single case I have seen where jurists say if a woman is raped, the judge should ask her if she was properly dressed, or if she tempted him, or if she was in a place at night, you know. And I think it's extremely important. I mean, you can have a discussion around whether women dress properly. That's a different discussion. But when discussing the crime of rape, it is very clear: the rapist is the criminal. The woman or the man who are the victims of rape are victims. And just like Noor said, you don't ask a man who's been the victim of armed robbery why he was driving a Mercedes-Benz at night. He should have driven a rickety car. And that's why you cannot ask a woman why she was dressed in a particular way. And in any case, as has been said, women are raped, men are raped, young children are raped, adults are raped, old women are raped, hijabi women are raped. So there is nothing statistically that shows that rape is tied to that. A rapist would probably, a person who would rape a naked woman on the street would rape a hijabi woman if he had the opportunity to. And he probably might rape a boy as well. So that, I think, is very clear under the law, that in the law of rape, the raped person is a victim. We do not ask what they did wrong. It was the rapist who did wrong. So if when we start from moving from zina to hiraba, we have consequence in terms of the law of evidence, and it's easier to establish rape. The second thing is also, the next stage is to say, what is the punishment for hiraba? And as Noor said in Surah Al-Ma'idah, there are basically 4 options available to the Qadi. There's because what says, you either execute them, or you crucify them, or you amputate limbs from opposite sides, right limb, right arm and left leg, or left arm and a right leg, or you exile them or imprison them. So in the 21st century, given our constitution, for example, if we say we will not take, we're not going to crucify, or we're not going to amputate, in our laws today, we do have death sentences. In our laws today, we do have prison sentences. And these prison sentences can be anything from short sentences to long sentences to life imprisonment. Now, to my mind, this gives us a great opportunity to look at rape, to define a law of evidence that acknowledges, that respects the testimony of the victim, along with circumstantial evidence that is purely consistent with Maliki law, and then to decide on a sentence that looks at the gravity of the particular situation. And what other Muslim countries have done is to define this gravity. So, for example, a man who rapes a child who's under 12 years or under 10 years old, a child is committing a much graver sin of rape, aggravated rape than a man who rapes an adult. A man who, or a person who has responsibility for protecting a child, say a parent or a family relation, or a driver who is supposed to take her to school, or a cook who has access, a trusted person who takes advantage of that, commits rape in an aggravated manner compared to somebody who is not entrusted with the protection of that child. A man who commits rape and while holding a weapon or accompanied by strong violence has an aggravated case of rape compared to one who does not apply such violence. Now, that provides the basis, I think, in legislation for saying this is 10 years in prison, this is 20 years in prison, this is life imprisonment, this is a death sentence. And all of that will be consistent with the positions on Hiraba and the Maliki jurisprudence. So broadly speaking, I think this is what would be if I were to draft a law or talk to scholars on the law, these are the kinds of issues we need to look at, taking inspiration from classical jurisprudence. The second thing, of course, is this is about the rapist. How about the person who is raped? The position of Maliki law is that if a woman is raped, she's entitled to what's called mahar mithil, which is the dowry that is consistent with her status. Now, we have this problem, of course, in Nigeria, where the dowry, the mahar, is usually very small, 10,000 naira, 20,000 naira. People give the minimum dowry. The interesting thing is, with Imam Malik himself, marital gifts, where they're considered as essential to the marriage contract, are actually taken as part of mahar. So really, if you want to estimate what should be the mahar for a woman, you'll be looking at, in northern Nigeria, not just the mahar or the sadaq, we're looking at what we spend on what's called kayan zenche, kayan lepi, all of that should just be added, and therefore in arriving at a financial compensation. And in any case, I think there would be a valid argument for saying that the fact that the scholars accepted payment of mahar simply establishes the principle that a victim of rape, in addition to the punishment for the rapist, the victim of rape is entitled to financial compensation. And we should then decide what is the appropriate financial compensation, because the principle has already been established in jurisprudence. So, when you're legislating for rape, you'd be looking at, is it zina or hiraba? And we would have to, I think, consider the implications because if you treat it as zina, as I said, you protect the rapist. If you treat it as hiraba, you protect the victim. Secondly, the standards of proof in zina are much higher than standards of proof in hiraba, and therefore taking it as hiraba allows us to catch more of the victims. The options we have between death sentence and imprisonment give us the ability to have legislation on punishment from imprisonment to death sentence, because I do think cases of men who marry who rape 5-year-old girls, for example, they should just be executed. I mean, I don't see any reason why they should even, some of them should not even remain on the face of the earth. Just execute them. And the law says it's hiraba, and yukatalu, it's an option. So the death sentence can be applied to aggravated rape cases. And then long prison sentences can be given to other cases. And finally, the financial compensation should be, again, such as to be a deterrent. So we do have the basis for, so you go to prison and you pay, or you even have a death sentence and you pay, because killing you or imprisoning you does not give the lady any benefit. And now we must also remember that in classical jurisprudence, the financial compensation is not just for the act of sex. If in the course of raping her, you cause her injury, there is an additional payment under criminal law. Qisas. You'll pay for injury. You'll pay for bodily harm. Now, these are, I think, the ingredients of a legislation around rape that is consistent, to my mind, with at least the Maliki. And it's not just Maliki. I mean, we've talked about Ibn Arabi and Qurtubi and Oleish and Ad-Dasuki, but this is what you find with Imam Shawkani, Nil al-Awtar. This is what you find with Ibn Hazm in Al-Muhalla. In fact, Ibn Hazm is perhaps the most articulate exposition of how rape fits into hiraba. And he goes to the extent to say, look, hiraba is not just about whether or not you're carrying a weapon, whether or not it can be in the forest, it can be on the streets, it can be in the city, it can be in a palace, it can be it can be in a home. You can carry an arm, you may not carry an arm. It could involve taking money, it could involve taking life, it could involve taking honor. All of that to him is hiraba. And he says there is nothing in the Quran or Hadith that limits hiraba to money. There's nothing in the Quran or Hadith that limits hiraba to taking life. It is the use of fear, the use of intimidation, the use of power to take away from somebody something that they've given without their consent is sufficient for it to be hiraba. And so we have, I think, enough resources, and this has always been my position. When we want to make these legislations, we should always go back to classical jurisprudence, look hard, and we'll find that many things that we say are not there in law are actually there. If we know how to look, and if we look very deeply into it. Now, the next question is, of course, the question of marital rape and domestic violence, which Noor has. And I would like to say that we need a little bit of nuance in this conversation. When we define marital rape as having sexual intercourse with your wife without her consent, you would run into a brick wall in Islamic law. And the reason is simple. The law says if you go into a marital relationship with your consent, that contract implies a consent to make your sexuality available to the husband. So by the time you agree to marry a man, you have given your consent for him to have sex with you. And this is the position of the scholars. Now, is this consent required in every single act of sex? If at a point in time your wife says, I am not interested, and you force her to have sex, or you have sex with her despite her saying she is not interested, what you have done is you have violated the sunnah. Okay, because there's a hadith of the Prophet that says, do not approach your wives the way beasts approach each other. Get her consent. Now, but violating the sunnah is not a criminal offense. And I think we should make that distinction. It is wrong, but it is not a crime. However, if in the course of trying to have sex with her, you use violence or you cause bodily harm, that is domestic violence and it is a criminal offense. So the act of sex itself is not criminalized, even though having sex without her consent is wrong and it is a sin and it's a violation of the sunnah of the Prophet and the instruction of the Prophet. It is not a criminal offense, but accompanying that with violence and with bodily harm and with injury enables the wife to seek criminal compensation for violence. So I think it's extremely important to make that distinction. So when people talk about marital rape, and it's broadly defined as just having sexual intercourse with your wife without consent, I think we must make that distinction. Having sexual intercourse with your wife without her consent and without violence and assault is wrong under the Sunnah. It is not a criminal offense. When it is accompanied by violence and injury, it is a criminal offense. But the institution of marriage, the contract of marriage, is a contract that allows the man and the woman access to each other's sexuality. Now, you can, of course, think of a case of possibly the woman herself raping a man. Yes, it may not be a ladylike thing to do, but it's not a crime. You know, she has a right to do it. And that is really the way the law has it. And I think one of the challenges that we have when we have these conversations is when you tell scholars you want to criminalize marital rape, what comes to their mind is you want to make it a crime for a man to have sex with his wife without her consent. So we need to make that distinction. Now, this brings me to the issue of domestic violence in general, and also the whole question of age of marriage and so on. And these are issues that we came across when we're trying to make the law. Now, take the case of age of marriage or wife beating. In Islamic jurisprudence, when there's a statement, a command, as we know, a command can be it could just simply indicate, oh, this is something that it could be something that is permissible. It could be something that is desirable. It could be something that is compulsory. So take marriage. Marriage is the sunnah, and marriage is desirable. In fact, in some cases, in the case of a person who cannot control his sexual urges and who has the ability to marry, it becomes even obligatory. Now, so marriage itself is sunnah, but marrying a woman at a particular age is a matter of choice. There is no value attached to it. It's just permissible. So nobody says that if you marry someone at the age of 6 or 7, you have a higher reward than someone who marries a woman at the age of 18. And if you take the Prophet's life, even if you accept, and again, like Noor, I have serious reservations about the hadith on the age of Aisha, but if you accept those reports, that you would find a whole range of years at which he married. When one of them, Khadija, in one of the narrations, say that Khadija was married at the age of 40. So if you take it the sunnah, it can be all those ages. Now, in usul al-fiqh, there is a rule. This rule is called Qaida Taqyid al-Mubah. It's a rule of placing limitations on that which is permissible. And the idea is, if something is just permissible, not desirable, and not obligatory, if it causes damage, the government can restrict it. So, for example, in Islamic law, the government of Nigeria cannot have a law that says you cannot marry, because marriage is sunnah. But it can have a law that says you cannot marry a girl before a certain age, because marrying a girl at a young age is just mubah, it's just permissible. It is not desirable, it is not compulsory. And that is, for example, when we started trying to write the law, my position was that we needed to have a minimum age of marriage. And this has been done in Morocco, it's been done in Malaysia, it's been done in Egypt, it's been done in Syria, it's been done in other Muslim countries. We were not able to do that. And you know, we had a long conversation. The law we finally had about 70, 80% of what I wanted. It didn't have 100%, but I was happy that we could get to 80%. And that, you know, we can also look at look at amendments. But in this conversation, I think we need to bring some nuance and some detail into this analysis. You know, we keep talking about the age of marriage, and I'm sure if you look at say the verse in Surah An-Nisa, وَابْتَلُوا الْيَتَامَى حَتَّى إِذَا بَلَغُوا النِّكَاحَ, you'll find that the different schools of law, when they talked about reaching the stage of marriage, gave a number of options. Some of them are the physical signs of puberty, but some of them also are using the age. And interestingly, in Maliki law, the age is 18. In Shafi'i law, it's 15, if you look at the tafsir of that verse. But in trying to write this law and fix an age of marriage and discussing with the scholars, I realized that there's a sense in which we also have an elite type of conversation. For all the people in this forum, for example, none of our daughters would be married before they finished secondary school, before they finished university, and they'd be 18, they'd be over 20. And it is inconceivable to us that a girl child, for example, will have nothing to do below that age. Now, as an emir and dealing with poor people in villages, you come across the stark reality that this issue may not even be a religious issue. It may not even be an issue with the scholars or with the people. We have been blaming the victim. Go to the villages in northern Nigeria. How many villages actually have secondary schools? How many have primary schools and teachers? Now the problem, if you take a man in a village, let's say there's a primary school in the village and the girl finishes primary school at the age of 11. There is no secondary school. There's no technical skills center. There's no provision for this girl for what she's supposed to do. Between the age of 11 and the age of 18, what is this girl doing? So, we can talk about a minimum age. We can say 18, we can say 17, but tell me, what will that girl be doing up to the age of 18? And you see, this is where in our discourse, we need to be honest and bold. It is easy to blame poor people for marrying off their girls at the age of 12 or 13. It is more difficult to blame a governor for not providing education for girls. It is easy for us to say we are so concerned about young girls. We don't want them to get married at the age of 13 and 14. Are we not concerned that they don't have an education? Are we not concerned that they're not being taught life skills? So if we actually focused on the rights of every girl to an education, say up to senior secondary school, and if we held our political authorities responsible for building the schools, for providing the teachers, for providing the scholarships, once a girl finishes secondary school, she's already 18. You don't get away from this debate about whether it is 17 or 18. If you go to the UK, if you go to the United States, if you go to Europe, all of these girls by 18, they have finished secondary school. But it is not enough to tell people, don't marry off your daughter until she's 18. What have you provided for her? So the difficult conversation we need to have is to ask ourselves, this age of marriage, and I went through a learning process because I became an emir with the typical elite mindset of our people in the north wanting to marry their children off. It was being an emir, coming face to face with the reality of poor people, that you realize that they want to educate the girl, but where is the school? Or she goes to primary school and comes out and she has learned nothing. And he sees education as useless. So if we really want to deal with age of marriage, and it is important, we should deal with education for girls and insist that our girls must be educated, and they must be educated up to senior secondary school. Because look, even now, there's a Universal Basic Education Act. The UBE Act makes it a legal offense for a girl to be married before she finishes junior secondary school. And it says that the imam or the pastor who contract the marriage and the parents and the house where it is contracted, all of those are offenses. How many people are brought to court for marrying off girls before they finish junior secondary school? They are not. Why? Because the schools are not there. The education has not been provided. So the person who is supposed to implement the law, the person who is supposed to take the children and take the parents to court, it is in the UBE Act. Yes, I saw somebody asking, yes, go and read the UBE Act. The person who is supposed to sue the parent for marrying off his child at the age of 13 cannot sue that parent because he did not provide the school. He did not provide the teachers. And so if we see that sometimes we are blaming a victim, I'm not saying that people need to be enlightened, maybe educated on the dangers of child marriage. We see VVF, we see a lot of the domestic violence that happens, but we must understand that the poor people in this country are victims of a system that has marginalized them. Their voices are not heard. They're crying. Their children don't have an education. The villages don't have the schools. They don't have the teachers. And we need to address these fundamental issues of development before we can succeed in our objective as far as age of marriage is concerned. Now, but the same principle of Taqid al-Mubah applies to this whole issue of wife beating. You know, when you talk about darb, It's true, there is a verse of the Quran that talks about how you deal with the woman in the case of nushuz, recalcitrance. And it says, وَاللَّاتِ تَخَافُونَ نُشُوزَهُنَّ فَإِذُوهُنَّ وَاهْجُرُوهُنَّ فِي الْمَضَاجِعِ وَاضْرِبُوهُنَّ. And it gives this three sequential acts of admonition and dialogue, and then desertion from separation from the bed, and then also this light beating. Now, it was one of the issues that we dealt with them with when we're trying to write the law. And I'll tell you again, my position is, if you look at Ibn Ashur, for example, Ibn Ashur in his tafsir, At-Tahrir wa Tanwir, talks about this case. He says, look, first of all, it is extremely difficult to define the scope of this beating. And even if you define it, it is extremely difficult for people to remain within the scope. So for example, if you take Maliki law, if you take the Muqtasar is very, very clear. It says that these three things are sequential. So you start with admonition. You try to talk to her. You try to talk to her parents, to talk to her. If that doesn't work, then you desert her bed for a period that does not exceed 4 months. If that doesn't work, and if you're convinced that a light beating will work, then you do this light beating, and this light beating is with a handkerchief or with a toothpick, and it cannot hurt, it cannot injure, you must avoid the face, and so on. You've got all these rules around the beating that, strictly speaking, when you read the Mukhtasar, it is a symbolic act, okay, of taking a toothpick or a handkerchief and hitting your wife with it. Now, Ibn Ashur says, if people are unable to keep within the bounds of that symbolic act, there is nothing in Islam that stops the government from having a law that simply says you cannot beat. Because that, even if the Quran says وَضْرِبُوهُنَّ, it is again like the case of the child marriage. It is an amr lil ibaha. It permits, it does not make it recommend. In fact, the Prophet ﷺ in various hadiths says, I have received reports that some of you beat your wives, and those who beat your wives are not the best. The best of it. I saw a correction. Yes, siwak is a chewing stick, not toothpick. Thanks for that note. Okay. Now, if you say that, so he says they are the worst of you, and if you actually look at the sabab al-nuzul, the circumstance in which that particular verse was revealed, it was the case of a woman who came to the Prophet ﷺ and said, my husband beat me. My husband slapped me. And he said, go and slap him back. That was the sabab. So the Prophet's position and the Prophet's guidance is that hitting your wife is not allowed. And therefore, no one can interpret that verse as meaning you can beat your wife, because the Prophet actually explicitly prohibits from slapping. So when we did the law, the scholars were not ready to take away the right to beat. We said, okay, well, let us write what the Maliki law says. So the law would provide you with the right to beat your wife with a handkerchief, but doesn't give. But if you slap her, it is assault. If you beat her now, I would have said just prohibit it. But sometimes in legislation, you have to make compromise, because if you don't take the scholars along, Malan Noor, what will happen is you pass a law, and on Friday, they stand up on in the mosque, on the pulpit, and say that you have passed a law that undermines the verse of the Quran and the hadith of the Prophet, and you will have non-compliance. And the judges themselves will have a basis for not complying, the Sharia court judges. So you have to take along with you the Sharia court judges. You have to take away with you the imams. You have to take along with you the traditional rulers. You have to get a consensus. So if they say we do not want to have a law that says it is criminal to beat your wife, and you know, it's interesting in the Northern Nigerian Penal Code, and I'm sure many of you probably don't know that it is almost embarrassing. But if you go to the criminal assault in the Penal Code of Northern Nigeria, it actually says, except when a man beats his wife. or when a man beats his servants for the purpose of disciplining them. It is actually there in the law. So the penal code of northern Nigeria actually allows a man to beat his wife. And so if you now want to get a proper Sharia decision, you either have to criminalize it or come back. My view is that you should criminalize, you should stop it, because at the end of the day, when you look at, when you talk about Taqlid al-Mubah, you must look at the maslahah, you look at the general interests of the ummah. It is not just, in fact, about the beating of the wife and the fact that the woman is brutalized, and that is a human right that's violated. But just think of it that in the 21st century, a community that allows wife beating is looked at as a backward community and is derogatory. Wife beating may have been okay in the 16th century, 15th century, and that was true. It was true of Muslim society, of Jewish society, of Roman society, of Greek society. But the world has moved on to a point where a community that allows its wife to be beaten is a community that is looked down upon. Now, when we are a community that prides ourselves in being khayr ummah, the best of communities, the model society, in the interest of protecting the dignity and integrity of the Muslim community, it is imperative on Muslim leaders to make wife beating illegal. And so, for me, these are challenges you get when you come to legislate. One of the things I learned was that if you try to run very fast, sometimes you lose the troops. You become like a general who's out there in the war, and the troops are not there. When we're having this law, we brought in scholars, we brought in NGOs, we brought in academics, and we sat down and debated. And like I said, the law does not have 100% of what everybody in this room would like to have, but it has 80%. Now, the final thing, one of the notes I made here is this question of a rape victim coming, and then people saying, "Oh, she's lying." Imam Ibn al-Qayyim in his book Turuq al-Hukmiyya looks at a verse. And this verse he looks at is Surah Al-Hujurat. Ya ayyuhalladhina amanu in ja'akum fasiqun binaba'in fatabayyanu. O you who believe, when a fasiq, a sinner, or comes to you with a story, investigate, check. And he says, look, Allah did not say that when a bad person or a sinner or and even Allah did not say when he comes with a story, reject it. He said investigate it. Now, if you are required to investigate, to confirm, and if you investigate and find that there is corroborating evidence, if it is true, you accept it. Now he says, if you are to investigate the statement of somebody who you know is a bad person, how much more when somebody who is not a bad person gives you a story? How can a girl come and say, I was raped, and without investigation, you say she's lying? In Turuq al-Hukmiyya, the Sharia is about finding the truth of an allegation. Of course, you will not hold the man and just throw him in jail because she says he raped me. But if you take the Turuq al-Hukmiyya, you are obliged to at least investigate that statement. Okay, where did he do it? What is your evidence? Were there any other witnesses? Take her to a doctor. Let the doctor look at her. Is evidence that she was raped? Is this person known to commit these crimes? Was he there? Was he seen? Because in evidence, even if he was seen in that place with her at that time, and she says he raped her, and it's established that she was raped, he's guilty. And so the idea that people should reject the evidence of anyone, not talk about a rape victim, does not happen, except in the special cases where you are commanded to reject, such as when somebody comes and says somebody committed adultery without 4 witnesses, then that is that is rejected. So these are, I think, I've tried to limit myself to the jurisprudence because I mean the whole issue of the moral issues and ethical issues have been dealt with. I would just round up by saying that the law only operates within the context of a society. You can have the best laws. Okay, we as people have to encourage people to come out and say that they have been victims of rape. We need to have a police force. We need to have a judiciary that understands that this is something that needs to be dealt with. We need to support it. I had a case in the palace of a woman who came to me and said she was battered by her husband, and she went to a Sharia court judge who said, well, why would you bring this to court? After all, Allah allows your husband to beat you. And I mean, this was a judge. He said that in open court. And we sent her to the Grand Qadi and said, look, you need to call this judge to order, because even if you have what kind of beating is referred to in that, what kind of beating is accepted by jurists. But this was a Sharia court judge. So you can have the legislation, you also have to train the judges, you have to train the lawyers, you have to get society involved. And at the end of the day, we must remember that the whole issue of rape is also tied to the general place of women in our society. I think especially, and I say this from northern Nigeria in particular, I think that we do not give women the regard and the respect that they deserve. It is the lack of respect for women that makes you think you can just take your daughter without her consent and marry her off to somebody. And again, if you look at someone like Ibn Qayyim in Zad al-Ma'ad, he basically has very harsh words for those who say you can even force your daughter into marriage. If you cannot, especially if she's an adult, if you cannot take her wealth without her permission, how can you take her sexuality and give it to somebody? How? How can you? You cannot take her wealth without her permission, but you are allowing her to give her sexuality to a man. Why?
I like this.
So if you go to Zad al-Ma'ad, you'll see that. So this idea of forced marriage, that people feel they can force their daughters into marriage, and you see, this is why I keep talking about education. If you have a law that says they must go to senior secondary school, by the time she finishes secondary school, she's an adult. Once she's an adult, you have strong grounds in Islamic jurisprudence for saying even the father cannot force her into marriage. And so you deal with so many, you're killing so many birds with one stone by educating the girl child. And I think what we haven't done as a community is focused enough. And the reason I think we haven't done that is not because we don't care, but because it is politically dangerous. Because the more you talk about the failure of to educate children, the more you point out the failure of political authorities to deliver what is important to society. We're spending our money building roads and building bridges and doing infrastructure where people who are walking on those roads are uneducated. They don't have healthcare. We need to get involved in how our money is being spent. We have a budgeting process where the governor or the president just comes out and says, this year, this is how much we are going to get. We're going to spend so much on this, so much on this. Who told you that what we want is a road? Who told you that what I want is an overhead bridge? I want an education for my child. This budgeting process should begin from what are the needs of society. And if we don't have an education, we should have 30–40% of our budget in education. If you don't have healthcare, you should have X% in healthcare. Now we can, yes, we want beautiful roads, but we can agree. We can agree that we can defer these roads while we educate our children, and then let our children, when they're educated, build the roads for themselves. So the conversation, and I think where maybe because I'm an economist, I think the conversation where the conversation lacks substance is that we treat it purely as a religious or cultural conversation. It is a conversation about development, about governance, about spending priorities, about making the welfare of the people truly. And this is what our constitution says. It's not me saying it. It's a constitution that says the welfare of the people is the primary objective of governance. So we cannot deal with these issues entirely without discussing these difficult issues around public policy, around education, around health, and around gender rights in general, and how we treat women. I think so that I limit myself to the area that I have chosen to speak about. I think I've covered practically everything. The only thing, the one thing again with domestic violence, I talk about wife beating, is that if you beat your wife in a manner that is not allowed by the Sharia, it is grounds for divorce. She can ask for divorce on those grounds. If you beat her and cause her injury, even if it is on the in a manner, for example, if you take a handkerchief to hit your wife and she jumps in fear and falls down a staircase and breaks her leg, you are criminally liable. Even though it was a handkerchief you took, you are liable criminally. These are all stated, and this is not the 20th century, these are all stated in the classical books of jurisprudence. And we need to bring out all of these things and make sure that they are in our laws, and make sure that our qadis implement them. Make sure that our women have somewhere to go for protection when these things happen. And that is where it begins. Rape begins from, you can beat a woman, nobody cares, you can abuse her, you can whistle at her, and all that. And finally, rape is not just about taking a gun or a knife or forcing her. It's also, there are other, in Islam, ikra, ikra has anything to do that takes away consent. So if you are a teacher and you have sex with a girl, you can't say, your student, you cannot say she gave her consent, because of the possibility that if she withheld her consent, there would be consequences. And if you uncle or somebody or a boss, you have a woman, you cannot say it's consensual because of the possibility that if she refused to have sex with you, you could sack her, or you could or she could lose her job. So long as there's a fear, of course, because Imam Ahmad bin Hanbal says that if there's a fear that a woman can go without food, or a fear that the woman can go out in the cold in the winter without shelter, if she does not agree to have sex with you and she says she gives her consent, that is forced intercourse. Because the only reason she gave her consent is the fear that she'll go without food, or she'll go, and if you use the same logic, anybody in a position where you can hurt someone who does not accept your consent, if you have sex with her, you cannot claim consent, because she does not have the option of withholding that consent without consequences. So it is rape. Now, these are the kinds of arguments that go into legislation. These are the kinds of debates that we need to have. And I'm not saying that if you had a law today, you'd have 100% of this, but if we try to get 80% of it, as we did in the family law, that would be a major step forward. And then we can, with amendments and with greater awareness,